ask you before you get started, Mr. Rudolph, would you prefer that we do it the way we've been doing it, or would you like me to put that there?
That would be incredibly
Is that
helpful.
right?
Hey, there you go.
There you go. I figure you probably need to see it more than I do. And
Thank you.
actually, let me restart you because I made up something out there. Okay, go ahead.
Well, I'm going to give you odds that that falls off before the end of the day.
Buy you lunch if it does.
Wait, what are the odds?
I don't know, lunch.
Okay, all right.
I did want to begin by saying I'm probably just going to briefly touch on sufficiency at the end of my argument and start on the second argument. Just want to touch on the facts briefly of what occurred. This is a murder case that involved a conspiracy and a murder incident. And just touching on the facts of the murder incident, this case involves Adolph Thornton, who is a well-known music artist, who was shot by two individuals at a cookie store in Memphis. This shooting was captured on video, both outside the store and inside the store, and showed a full depiction of what occurred. At trial, the state sought to introduce photos of the crime scene, and the court allowed one photo that depicted, it's in the record, Exhibit 35, the victim on his backside with a gunshot wound to his head, a serious gunshot wound to his wrist, and several gunshot wounds to the torso. The court erred in introducing this, as we stated in our brief, because the probative value is substantially outweighed by unfair prejudice. As I stated, well, let me take a step back. The court, in its ruling on this, I believe cited proximity to the window as one of the reasons, but sort of was admitting this photo to give the jury an understanding of where the deceased was from the crime scene. As I stated previously, there is a high-resolution video, Exhibit 5, in Volume 14, that depicts the entire incident. You can see the defendant on that video being shot. You can see the two suspects who shot him. You can see where he lands. And even in the video almost seems to, and I didn't include this in my brief, but I did want to touch on this. The video almost seems to contradict some of what I believe the court ruled on. I believe the court made a finding that that his body was, in essence, in the photo, Exhibit 35, how it was at the crime scene. But in the video, it showed the defendant falling on his stomach halfway out the window. And in the photograph that was introduced that we're making this issue on, he's on his belly completely inside the store.
Was that explained in the proof?
I think there may have been, and I was looking for this in the record and couldn't get to this, that a paramedic or his brother was present with him, may have moved the body, and that might explain that, and I do need to touch on that. But as far as just giving an accurate depiction of the actual murder, the video is much more probative. It shows the body, if the body was moved by a paramedic or was moved by his brother, the video shows a more accurate depiction of where his body fell. And the video shows how many gunshots were fired and does it in a much less unfairly prejudicial way.
Explain that to me, why the video that shows all the things you referred to is much less prejudicial than a single photo.
So the video, in the video, the exterior video of Exhibit 5, you see the victim be shot and fall through the window. You don't get the close-ups of the wounds, and the wounds I felt were very gruesome and gory. And when I think of what was missing in the photo, or excuse me, in the video that you get in the photo, is kind of gore. He has, in the Exhibit 35, the photograph, he has a large pronounced gunshot wound to the cheek. He has what appears to be an entrance and exit wound on his wrist. His torso is very shot. It's very blood-soaked. Just to be frank, it was a very disturbing photo. Whereas in the video, he falls over, as I said, stomach first through the window. there isn't as much bleeding because of how quickly the incident occurs. I don't remember seeing any large exit wounds, any exposed flesh, all of which you get in Exhibit 35.
I'm looking at 35, and I also see evidence markers on the ground. I see 51 and 52, and then partially I can see it looks like 53. I believe the prosecutor below mentioned shell casings. I don't want to speculate, but do we have any indication what these evidence markers were and what their significance was?
It could possibly be shell casings. I don't remember at this time what those were. There were a lot of shell casings because there were 2 guns used and a lot of rounds were fired. But I don't remember what those placards specifically.
Would that be important if there were shell casings inside where the victim's body was?
Yes, and they may have admitted photos of where the shell casings were with the victim's body removed. I see that in a lot of cases. I don't remember if that occurred in this case. I think what is really important is if the victim's body was moved, which just looking between Exhibit 5 and Exhibit 35, it did seem that at some point it would have had to be moved by a paramedic or his brother trying to render first aid. Then the probative value, I just don't see it. I don't think there is much because it does not, as the court said, kind of depict where the victim is in relation to the window. The probative value the court made in its ruling is significantly diminished. And as I said, it's a very prejudicial, gory photo. In regards to the autopsy, I believe there was one photo objected to. It was a close-up of the victim, Mr. Thornton, with some of those gunshot wounds I touched on. He has, again, the very pronounced gunshot wound on the cheek. I know that Tennessee courts have held that if medical examiners' testimony is sufficient, then a gruesome or gory photo should not be admitted, and I believe that the court should not have admitted this. I believe that the medical examiner could have adequately described to the jury the extent of the wounds.
Did the court have an opportunity, the trial court, to actually make that determination? Was that one of the state's argument below, that this will assist the medical examiner? The one photo of the autopsy?
There was, I believe in the record, and I believe I'm correct about this, there was an objection to several photos.
Right.
And the court made a determination and admitted one that defense counsel objected to.
I think there were 11, right?
11, yes.
Okay, so, and the court chose one.
Yes.
And admitted it. So in that way, the court was conducting kind of a 403 analysis to all of them and found that one will meet the criteria and should be admitted, correct?
Correct.
All right, and we're under an abuse of discretion standard, correct?
Yes.
Okay.
But I would argue that the court did abuse its discretion because there was not, because of how unfairly prejudicial the photo was, and the heavily diminished, especially if Exhibit 35 is introduced, it's almost redundant. It's showing a lot of the wounds you can see in Exhibit 35. So I would make that argument. It's a lot of the same wounds. There was also the issue of defense counsel asking the defendant to sit at counsel table. I believe at 2 separate points he made requests to the court to sit at counsel table. While it's not an absolute right, the Tennessee Supreme Court has stated that it is the best practice. And what I really want to draw the court's attention to is the findings of the trial court. The trial court, when confronted with this request, made findings that the defendant was respectful in the courtroom, that they had never had any problems, and made it made a ruling that he is an inmate, and this is a serious matter. And I would argue that that's not only not sufficient findings to find that the defendant should not sit next to his attorney, those findings actually support the defendant sitting next to his attorney.
Will you focus on the prejudice, what prejudice defendant or the appellant experienced through sitting behind his counsel?
And it's always the part that's kind of tough to measure. In the record, the defense counsel made a argument that, in essence, the appearance of him sitting behind it was prejudicial. The sort of barrier to communication, having to turn around, draw your attention away from the proof. You know, I don't know if the record's going to be particularly clear about what prejudice there is. It would be kind of the prejudice that one might expect of you're behind your attorney, just the appearance of not being able to sit next to your counsel being viewed as a security threat.
Was he dressed out?
I believe he was dressed in normal, non-jail attire throughout the entire proceeding. I don't think there's any issue in regards to that, but he was seated probably 2 to 4 feet behind defense counsel.
Was there a physical barrier of any sort between he and counsel?
There's no physical barrier. Counsel, in Shelby County, that's why I typically have to push my chair out and turn around, but still, he doesn't get to sit with his attorney. There's going to be a barrier in communication. And any time he wants to speak to his attorney or, suggest a question for a witness, the attorney has to turn his head away from the witness. And I think defense counsel touched on this in the record, take his attention away from the proof to address on that.
That's kind of true with every conversation with your client, though, isn't it, Winston?
It is. It's, if they're whispering in your ear and you can kind of keep your eye on the witness, it's one thing. It is a little bit more if you're, pushing away, turning your head 180 degrees and completely departing your attention from the proof.
Is that fairly common practice in Shelby County, or was that unique to this case?
It's somewhat common. It depends on the courtroom. I think I wouldn't want to speculate without having proof.
I was just curious.
I was curious too. I'm glad you asked.
And my final, the final argument was the court, or firstly, the state did not charge Hernandez Govan, who was the alleged sort of centerfold of the conspiracy in this case. The court issued a missing witness instruction that would allow the jury to potentially draw an inference that his testimony may not have been favorable to the state. The state, in their closing argument, sort of turned this on its head, and instead of addressing on the missing witness instruction, made this a Fifth Amendment issue, pretty much insinuating Mr. Govan would have certainly asserted his Fifth Amendment right not to testify, and sort of drew the jury's attention away from that missing witness instruction. Importantly, too, there was no proof in the trial that Govan would have asserted his Fifth Amendment right to remain silent. He very well could have testified. He did have a proffer agreement in place with the state and had spoken to them freely previously. They also called 2 witnesses to this case who were co-defendants. The other, Mr. Johnson and Cornelius Smith, and there was one other witness, I believe, that was facing separate criminal charges who was called as a witness. In light of the circumstances, I think this is totally improper, that this is proof that's not in the record, it contradicts what the state's been doing throughout the legal proceeding. The court didn't take any curative measures. I probably should take a step back. Defense counsel did not object to this. We're addressing this under plain error.
So,
Yes.
so when did the state make this argument? Was that in their initial or their rebuttal closing argument? I'm just curious.
I'm not sure. I believe it was in the initial. I don't think I put that in my brief.
Was, also, I haven't looked at the whole record, but was, did the trial court instruct the jury before or after they argued? What I'm getting at,
Yes.
was the prosecutor responding to this, or was it anticipatory response?
I believe it was responding, and I could be wrong. I believe the court would have instructed potentially prior to closing. That was my recollection of it, but I could be wrong about that. And I believe it was responding. I believe my recollection, like I said, I could be wrong, was that the jury had already been instructed as to missing witness, and that the court and that the prosecutor was in essence responding to something that had already been instructed.
Was he missing?
So he was a state's witness with a proffer agreement that I do not believe defense counsel had called, and I do not believe the state had called.
So he had
Had
been
what?
listed on the, I'm sorry, Judge. Go ahead.
They hadn't what? What was that last part? I couldn't hear.
That the state had not called,
Had
nor
not
the
called.
defense.
Gotcha.
And
Okay.
I think the argument was he was available to the state, but not available to the defense.
Why would he have been available to one and not the other? Could defense not have subpoenaed him?
They could have. I didn't do a ton of research on that issue since it was instructed.
He was in custody, I guess, is my point.
No, he was out of custody,
was
I
out?
believe. Yes.
Okay.
My understanding was he was out of custody throughout the entire legal proceeding.
Was he listed on the indictment as a witness for the state?
So I believe he was listed in the indictment as a defendant, and I could be wrong. So I believe he's on the indictment as a,
Yeah, he was a charged co-defendant.
Yeah.
Oh, he was charged. I thought you said earlier that he was uncharged.
he was charged, and he had a proffer agreement in place with the state.
You see your minute.
Oh, yes. And then, if I could touch briefly on sufficiency, I'll keep it in like 30 seconds. My main point on sufficiency is in the brief was in regards to the conspiracy, that there had been no meeting between my client Hernandez Govan to form that conspiracy to commit the murder. I think that also may have tied into why he was not called. And if there's no further questions, I would ask the court to reverse my client's convictions.
Thank you, sir.
Thank you.
General?
Good morning, Your Honors.
Morning.
Harvey May, on behalf of the state of Tennessee, representing the Attorney General's office. This court should affirm the judgments of the trial court and affirm the judgment of the jury. I will address the issues. One, I want to point out one issue. I think Judge Wilson, I don't remember if it was Judge Wilson or Judge Hickson, regarding to the autopsy photographs. There were 11 total autopsy photographs that were entered as exhibits. Only 2 were objected to by the defense counsel. Both were of the, I believe it's right cheek entry area. One had a full-blown view of the face, and one was just a close-up of the gunshot wound to the cheek. Those were the only 2 objected to by the defense. The trial court reviewed actually all the photographs that were autopsy photographs, not just the ones that entered. The parties discussed it. The trial court found that the one that was the farther away but showing of the entire head was cumulative of the other photographs, and as well as more, it found more gruesome than the other one, the close-up. And in regards to that also, in addition, the medical examiner used each of the photographs, all 11 photographs, to describe the entry wounds, the nature of the wounds, where they're entered, where they're exited. There were 20 total gunshot wounds.
But the examiner used the one that's at issue here, right?
Yes,
Okay.
including this one, to describe the nature of the wound, how it entered, and what caused injury that followed. And that is clearly not an abuse of discretion here. The court went through the factors, considered the potential prejudicial effect, found it relevant to issues at trial, and clearly that those was a proper use of his discretion. In regards to the crime scene, the one crime scene photograph, there were multiple crime scene photographs. There was a video. The video, as the testimony you will see, it is exhibit, I think 5, shows the gun, the attack, and the numerous shots and what was struck. The victim does fall off screen and does fall down, and what the photograph was used by the prosecution, and the court again reviewed all the crime scene photographs and did the same procedure here, those not entered and not entered, and determined that it was relevant to issues at trial regarding the nature of the attack, the premeditation, the intent of the parties, as well as showing that multiple individuals, 2 individuals were involved in the shooting that was shot, the victim here, that it showed the proximity not only to the window. The victim was inside the store at the time. The shooters drove up, stalked him, drove up, and shot him while he was standing inside the broad daylight at the store. But it showed how he collapsed in the store, the area where he collapsed to, the nature of the damage, as your honors noted, the crime scene photo documentation, the markers showed not only shell casings that were close in proximity, but also bullet strikes you could see in there, and the damage that showed where he was in the building and the nature of the attack and the brutality of the attack. And it was not an extreme close-up. You do see some blood, but the court went through the analysis in regards to the relevance of it as well as the prejudice effect, and found that was not inappropriate and prejudicial to the defense. Thus, it did comply with its analysis and did not abuse its discretion by introducing those. I'm going to trying to go through in the order that my friend on the other side. The next thing I think that was addressed was the defendant's request to sit at counsel table. And as my friend on the other side, we were both practitioners, or I was a former practitioner prosecutor at Shelby County. It's not usual for defense to request to sit at counsel table. I prosecuted there 20 years. It's just not usual. It does occur, and the courts typically go through an analysis and discuss it here. What my friend on the other side did not address is this was a high-profile, gang-connected case that's clear through the record, through the process. This was a case that had to be change of venue for the selection of jury. I think it was selected in Davidson County. I'm not 100% positive, but I believe that's correct. And then they transfer back. While in jury selection, defense requested, and I'm not familiar with that courtroom, did request for his client to sit at counsel table, and the trial court reviewed that request and noted that while no specific issues known at that moment by counsel, there was high security concerns throughout the process, and the court later described a little more detail that they had extra security DRT officers around in place, and there were other security concerns due to witnesses that were being put on the stand about videoing, not videoing, a lot going on, and that the trial court in its analysis also referenced that the deputies had expressed concerns about this, about the location of the defendant. The trial court also discussed in detail when the defense counsel moved forward again at trial, pointed out that it was only a few feet from his counsel, that he was in normal citizen clothing, not jail clothing. He was unhandcuffed, and that if there were issues or concerns that the defense could address, to pause the proceedings, to address his client or talk to his client, even though it was only a few feet away, and that it was never raised again.
So that last
No, go ahead.
that last part, was that during, when we look at the record, was that during the trial where it was raised again and counsel said, look, I'm trying to talk to him, I can't do it, and then the procedure, the court saying, hey, we can take a break if you need to? Was that during the proof?
It was prior to the proof. If I remember correctly, this was at the beginning stages of the trial. Once they transferred the actual presentation trial, pre-trial, the defense counsel, I guess the morning of the trial, if I remember correctly, addressed that issue again. So jury was no one else in the courtroom, and the court addressed those things and its considerations, and also addressed it again. And the defense never raised an issue again.
Okay.
in regards to that throughout the trial.
Did the trial court or anyone ever explain what the deputy's specific safety concerns were with the defendant sitting at counsel table?
No, there was not a detailed discussion of it. It's readily apparent, and we may not have all the record we don't have the record from any pretrial proceedings regarding this, or like change of venue and things like that. There was a lot that's not in the record here, the appellate record. But it's clear from the court's findings and even defense counsel's comment that it was aware that there were concerns of the court.
Because and let me just say, my entire career, I'm not a security guy, so I was always very happy to defer to the professionals who do that for a living. But just sitting up here thinking, I'm trying to figure what safety concerns would have been satisfied if the defendant was sitting directly behind his defense attorney with no physical barrier between them versus sitting next to him at the table with no physical barrier next to them. Was that ever articulated, or?
Not in this record in detail, no, Your Honor. I'll be clear. I mean, having practiced there, I know the deputies are very concerned of being able to intervene if there were some issue, that space. I know in my practice, when I've had this issue raised, the deputies want to be able to intervene if there's some issue before anything can happen. And but it's not clear in this record.
Are they placed in a better position to do that?
Yes.
If the defendant is, how so?
The deputies are typically in that courtroom. The deputies are standing at the doorway next to the clerks and within feet of the defendant. In this case, again, I was not there. The record's not very clear. There were also DRT officers. There's not been an objection that there were DRT officers, which are the higher security officers. So I don't know where their placement was, but there's not an objection that they were there. But there was evidence of references to additional security in the courtroom.
I assume you don't know if those additional security forces were in civilian clothes or if they were in uniform.
It is not clear, and there was never an issue raised as to that, Your Honor. But the court, and again, it's abuse of discretion. The court considered that, reviewed that. This is not like, I believe, one of the cases cited where the court said, well, you're not a lawyer, you can't sit at the table. The court went through went through its analysis and finding that there was security concern, found that there was no prejudice by where its placement was in the courtroom. And the defense simply cannot show that there was a prejudice. There was no further objection or raising issues that I can't communicate with my client or anything else like that throughout the record. It just was not raised. And so the defense cannot show prejudice into this. The next issue that was raised and discussed by my friend on the other side was the discussion of the material absent material witness instruction. I think the defense at trial and the court maybe conflates a little bit of what's immunity and what's a proffer agreement. I believe Your Honors and y'all's past experience, there's a significant difference. And the defense has not cited at trial or in its briefs any requirement that the state offer a defendant immunity, or that there was required to do that, or that the defendant would have been willing to testify. Again, this is, as Judge Schwartz noted, or I believe, that this was a co-defendant. This was a severed co-defendant who has representation. And while there's been a proffer agreement, that does not require that defendant to testify at his own trial or at the trial of another co-defendant. He has just as many Fifth Amendment rights as the defendant there today, or in this matter. And so there's a very big distinction. And again, I believe Judge Dixon pointed out, the defense counsel could have subpoenaed the defendant. He was out of custody. It's clear from the record. He was tried later, subsequently. So this was a defendant that was clearly not complying with the proffer agreement, or not willing to testify, or not willing to participate. He was subsequently tried after the fact. The parties were very aware of that. The defense counsel did not seek to subpoena him to show that they had no ability to get him there. They just made the reference that I can't force him to testify. Well, neither can the state. Every defendant has a Fifth Amendment right not to testify. And the court did grant the instruction upon the defense request. The instructions were given before closing arguments. And my memory serves me that the state did not really address this issue at all in its opening close. The defense counsel addressed it at length in its closing.
So you believe that was a fair response? I mean, Judge Hickson asked the question, I've seen it done many times where it's raised, where's Jeff Jones? And then the rebuttal closed by the state, defendant has same subpoena power we do. I mean, that happens all the time.
And the state didn't even go to that far.
Okay.
The state just simply, and I think it's very important, and I've got the jury instruction, it's 4216. The instruction actually, and this is what was provided to the jury, whether there's such a witness and whether such an inference has arisen is for you to decide. And if so, you determine the weight that should be given. That's all the state argued in its closing argument, is that this was not truly a missing material witness, and that the defense that should not be afforded that inference against the state. And that,
If I'm hearing Mr. Rudolph correctly, I think one aspect of this he's taking issue with is that the state basically argued this was because of his Fifth Amendment right not to testify. And it doesn't sound like that particular fact was established in the record, that that was the reason he wasn't there and wasn't testifying. What do you make of that argument?
well, so how this was raised to get to the point where the defense asked for the jury instruction is when one of the case officers, and I don't remember the name off the top of my head, it's cited in my brief, but when he is being cross-examined by defense counsel at trial, they asked him, did Mr. Govan have a proffer agreement? And the defense counsel, and the officer answered, there was interviews and a proffer. Then the defense counsel asked a further question closer to the immunity type issue, and the state objected. Again, arguing that it wasn't relevant and an improper question. And the court sustained it. So it didn't go further than that. And that was the only reference to whether any party was testifying or not, or whether Govan was a party. It was clear in the record that he was a co-defendant. He was in the indictment, which was read to the jury. So, you know, the immunity part of it, whether it was granted or not, the Fifth Amendment right, that didn't go as far into it. But if you look at the defense closing argument as well, and the state's in response, that was the reference from both parties, and it just with a different angle on it. And again, the state was simply arguing that the jury instruction was not applicable to this situation, and which is the inference that the court instructed the jury could consider whether it was appropriate. Simply because a court gives instruction doesn't, and there are other instructions that allows the jury to make inferences or not inferences from instructions of flight and other types of instruction. That's simply the argument that went on here today, or at the trial. And as to the defense last discussion, and I've lost my clock. I got about 4 minutes. I can barely see. You're fine. I can barely see it. So as the defense, the final issue raised by the defense was in regards to conspiracy. The defense, on my friend on the other side, focused solely on that his client did not participate in the initial meetings between Mr. Govan and Mr. Mims, who was also known as Juke. And it's confusing through the record because it doesn't mention what his real name was, Anthony Mims. He's referred to as Big Juke or Juke throughout the entire thing, and you find out at the very end it was Anthony Mims. But Anthony Mims and Hernandez Govan were the ones that had put out the hit, $100,000, and they met with Mr. Smith, Cornelius Smith, who was the co-defendant who cooperated and accomplice testified, one of the shooters actually at the scene. However, if you look at Patel and the chain of conspiracy, he doesn't have to participate in every conversation. He doesn't have to participate and know exactly all the individuals involved. However, the evidence is clear about the conspiracy. So Mr. Cornelius Smith testified throughout the trial about the meetings, about being introduced to the defendant, Mr. Johnson, and by Mr. Govan, and that, I believe, or Mr. Juke, Mr. Smith, Mims, and that they met. And then subsequently to being introduced to partake in this criminal conspiracy, which they agreed to split the $100,000 and give $10,000 apiece to Mr. Govan for putting them together for this hit. Mr. Smith testified that he and the defendant met multiple times after that to discuss and plan out how to do this and when to do this. But don't leave it just on Mr. Smith. The defendant, on the night before, the day before the homicide, communicated with the next individual involved, Treon Ingram. He did not testify, but there are cell records between the defendant and Treon Ingram coordinating getting the white Mercedes that was later used in the homicide. You can actually see it on the videos, both at the homicide scene. And then you have the testimony of Mr. Kristen Garner, who testified that he was with Mr. Ingram when they delivered the car to the defendant. This is 3 in the morning of the homicide, and that there was an assault rifle and pistols in the car at that time. And he testified at trial. But don't leave it on to just Mr. The Kristen Garner. The defendant's own cell phone records and the videos from crosstown apartments where the defendant lives, as well as the Valero gas station, and the defendant's cell phone records show that he was at those locations and met those when those events occurred, and that he had the white Mercedes back at crosstown apartment. But so you have those things connecting him, and the defendant even texted Hernandez Govan's street to where the Mercedes was later found to Mr. Ingram. So the connections are all there, showing circumstantially there was an agreement and that the defendant actively participated in it. But don't leave it there. Again, back to the Mr. Smith's own testimony. He testified that the defendant called him the morning of the shooting, about 11:30, 12. It's in the briefs and in the record. That morning, the defendant's own cell phone showed that he called Cornelius Smith that morning, and that the defendant's own cell phone records showed that he went and picked up Cornelius Smith and drove him to the scene. All that shows a detailed level of the accord, the agreement, that he was actively participating in, and the overt steps that he obtained the car that was to be used. He didn't use his own car, which he had before and after the homicide. He used a separate car that was a stolen car from Theon Ingram. There's a lot in the record about that. And that they end up shooting. And then after the homicide, again, Mr. Smith testified that they FaceTimed Hernandez Govan and afterwards. The defendant's own cell phone shows that he FaceTimed him in the car after the homicide. We don't know what was said, but everything connects together. In the end, the state's asking this court to affirm the judgments of the trial court and the verdict of the jury. Thank you.
Thank you, General. Mr. Rudolph? I believe you have 2 minutes.
Yes, Your Honor.
How is the state supposed to argue against this missing witness instruction other than how they did? What would be an acceptable way for them to argue that?
The missing witness instruction?
Yes.
Well, I certainly don't think that they can assert the Fifth Amendment and say he's a defendant, he wouldn't, defendants have a right not to testify, and base their entire argument on the Fifth Amendment right to testify, which we don't even know if Mr. Govan would have asserted. I don't know strategically necessarily how they should do it, but they should make sure that they're not arguing facts that are not in the record. He does have a right to a Fifth Amendment to not testify, but in his proffer he waived that, and he very well could have waived it if the state had called him and testified.
Or if the defense had called him.
But again, he had that proffer agreement with the state. so he was certainly more available to the state. But I think you could argue against the inference, but I don't think you can go so far as to say, oh, this is all about the Fifth Amendment and whether defendants have a right not to testify, and that's an essential right, and that's really what this is all about. And I did want to, in my limited, I'm out of time, or close to out of time.
I jumped in with a question. If you have a brief point you want to
Sure.
make, please go ahead and do that.
So in regards to sitting at council table, the court did make findings. This was a high-profile case, that there were security threats. A court can commit plain error when it makes a decision or a ruling that's contrary to the proof, common sense. Where Mr. Johnson sat was closer to the gallery, was closer to threats. The court found he was not a threat to his lawyer. He had conducted himself well. I do not believe he's in any better position being behind versus next to his attorney. His attorney's a barrier between him and state counsel, between him and witnesses. I would argue that the court's ruling was contrary to the present situation.
Great. Thank you, sir.
Thank you.
Thank you, counsel. You good? You good? Yeah. Okay, we're going to take a brief 5-minute recess.
All right.